Hello, and welcome to the City of Austin's Ethics Training for City Board and Commission members. I'm John Steiner, the City's Integrity Officer. I'd like to begin by thanking you for serving as an appointee to a City of Austin Board or Commission. Our city depends on the dedication of community-minded individuals to perform many of its services and regulatory responsibilities. The sacrifice of your personal time and service to your community is greatly appreciated. However, additional responsibilities come with public service. In order to ensure a fair and open government, public servants are subject to laws and regulations concerning their conduct. If your experience has been in the private sector, the rules that apply to public servants may be new or even surprising to you. Many situations that are considered ordinary business practices in the private sector are not allowed in the public sector. The laws that regulate your conduct as a public servant are generally referred to as ethics laws. You might say that these laws signify the seriousness of the work you're about to undertake. Your actions as a board or commission member affect the lives and fortunes of the residents of our city and surrounding communities. As a result, violating the laws that govern your conduct as a public servant can result in more than just public embarrassment. It can result in criminal liability. This training is offered to help you avoid these pitfalls. It will introduce you to the ethics laws and regulations that apply to your position with the city, and perhaps more importantly, provides you with an understanding of the purpose behind the creation of such laws. An understanding of the purpose behind these laws will help you avoid situations that may lead to a violation.
Hello, I'm Kim Barnes, and I'll be conducting your ethics training today. The Code of the City of Austin states, "It is the policy of the city that the proper operation of democratic government requires that public officials and employees be independent, impartial, and responsible to the people, that governmental decisions and policy be made in proper channels of the governmental structure, the public office not be used for personal gain, and that the public have confidence in the integrity of its government." These are the goals behind the creation of ethics laws and regulations. In that spirit, the City of Austin presents this training to give you the understanding you'll need to comply with the requirements of these laws. Let's begin with some basic principles.
What are ethics laws?
Ethics laws are basically a code of conduct for public servants. All laws are to some extent about ethics, but the laws that we generally think of when we talk about government ethics are laws that support one of the following 5 principles of good government. The first principle is transparent and impartial government. Good government does not function in the shadows. The public has the right to know what its government is doing. Next is decision-making free from personal interests. A public servant's duty is to serve the people, not to serve their own interests. The third principle is decision-making free from gifts, bribes, or intimidation. The citizens of Austin expect decisions to be made fairly with the best interest of the community at the heart of every decision. The citizens are trusting you to be true leaders, leaders that are not swayed by bribes or intimidation. By supporting these first 3 principles, you ensure the fourth principle, the public's confidence that the resources entrusted to you are being used wisely and in the best interest of the city. This final principle, public faith in the fair administration of their city, flows naturally from all the others. An open, transparent government that uses its resources wisely and centers all decisions in the best interests of the public inspires the public's faith that its government is administered fairly. These 5 principles and the goals set out in the City Code are the driving force behind the ethics laws. You should keep them in mind throughout this presentation and during your service to the City of Austin. The city has many citizen boards that are called many names: board, commission, committee, council, task force, and so on. These terms are synonymous. Some boards are permanent and some are temporary. The ethics laws apply to all of them. However, for ease of reference, I will simply use the term board or board member during this presentation. Because city boards play an important role in the creation and execution of city policy, it is important for board members to avoid even the appearance of a conflict of interest.
What is a conflict of interest?
A conflict of interest occurs when your personal interests intrude on your ability to make fair, unbiased decisions, or when it would appear that way to an observer. Or to put it more simply, it is a conflict between your personal interests and your public duties, even if it just looks that way. It is important to understand a few basic ideas about conflicts of interest. Anyone can have a conflict of interest. A conflict is merely a situation that exists. The existence of a conflict of interest does not say anything about the personal honesty of any individual or whether the individual will be influenced by the conflict. A conflict of interest does not imply that a person has done something wrong. No matter how honest a person may be or how able a person is to set aside his or her personal interests, if a conflict exists, it undermines the appearance of fairness and impartiality, and it undermines the public's acceptance that all public decisions are being made for the public good. Some very knowledgeable board members may be excluded from participating in some board actions because of conflicts of interest. It is frequently true that expertise in a particular subject coincides with a conflict of interest in the same subject matter. In this case, fairness and impartiality and the appearance of fairness and impartiality are valued by the process more highly than the expertise that is lost. If you have a conflict, it doesn't matter whether you intend to vote for or against your apparent interest. Conflicts can arise for various reasons. Typically, however, they are caused by financial interests, occupational concerns, and personal relationships.
How can I tell if a situation creates a conflict of interest?
When a matter appears on your board's agenda, ask yourself some simple questions. Do I stand to lose or gain anything because of my decision? Do I have a close personal or financial relationship with an interested party? Have I received a gift or hospitality from anyone who stands to gain or lose from this decision? Will this affect my future employment opportunities? How would I feel if I saw a story about my connection with this issue on the news or read about it in the paper? Would I be embarrassed if people found out about my personal connection to this issue? If any of these questions causes you concern, you probably have a conflict of interest. Remember, part of our definition for a conflict of interest was that a situation appeared to an outside observer to cause a conflict. It is not always enough to be able to set aside your personal feelings and be totally objective. There are just some situations that appear to be a conflict no matter how honest or detached a person is. Public opinion counts. If it looks bad, don't do it. If you are still unsure whether you have a conflict after asking yourself these kinds of questions, you should talk to the legal counsel assigned to your board. You can also call the city's integrity officer to discuss the situation.
What should I do if I decide I have a conflict?
The rules governing your conduct deal with conflicts of interest in three basic ways: through prohibition, through recusal, and through the use of your personal judgment. A conflict that triggers prohibition is a conflict that is so significant that it prohibits the conflicted service. In other words, the conflict would disqualify you from serving on the board, or serving on the board might close a private opportunity that would otherwise be available to you. A conflict that would require recusal means you have a conflict arising from a specific matter before the board. Recusal means that you may not take part in the decision-making process concerning the matter. You remove yourself from the discussion and the vote. If a particular conflict of interest is not addressed by the ethics laws and regulations, you must use your personal judgment to decide what to do. Rules cannot anticipate every conflict that could occur for each individual public servant. Let's look at some examples of conflicts that would prohibit you from serving on a board. You are disqualified from service on a city board if at any time during the last 3 years you were registered as a lobbyist, required to register as a lobbyist, or an employee of a person required to register as a lobbyist under the City Lobby Ordinance. Registering as a lobbyist under the City Lobby Ordinance is not the same as being required to register with the Texas Ethics Commission under the State Lobby Statute. A person or business may be required to register under the City Lobby Ordinance if the person or business receives compensation or reimbursement or makes expenditures in connection with directly communicating with certain city officials or employees on municipal issues. Whether registration is required depends on the nature of the communication, to whom the communication is directed, and the nature and amount of the compensation, reimbursement, or expenditure made in connection with the communication. If you or your employer receives income or makes expenditures of this nature, you should make sure that registration as a lobbyist is not required under the city ordinance before seeking to serve on a city board. The City Lobby Ordinance is found in Chapter 4-8 of the City Code. Compliance with the City Lobby Ordinance requires intimate knowledge of your finances and activities. It is the personal responsibility of the person required to register to comply with the ordinance. If you have questions concerning your particular situation, you can call the City Integrity Officer. A city board member may not appear before the board of which he or she is a member while acting as an advocate for himself or herself or for any other person, group, or entity. In other words, you can't be a member of a board and appear before the board as a member of the public. Most city board members are prohibited from service on more than one board at a time. There are a number of exceptions to this rule. If you seek to serve on more than one board, you should make sure that you are not subject to the general rule prohibiting service on multiple boards. For example, if you are interested in urban renewal, you should be aware that becoming a city official may restrict your ability to own an interest in an urban renewal project. Contracting with the city is another area that can lead to problems for board members. It is not generally prohibited for a board member to have a contract with the city. However, many city boards play a role in the solicitation of city contracts. This may include advising on the specifications of a solicitation, the evaluation of responses, or on the final award of the contract. If you have or will seek to have a financial interest, direct or indirect, in a particular contract, you may not participate in the development, evaluation, or decision-making process of the solicitation for that contract. If you have played a role in the solicitation process as a board member, you will be prohibited from being a contractor or subcontractor on the particular contracted issue. If you are in a business that seeks city contracts, you may want to consider service on a board where this kind of conflict will not be an issue for you. Let's review. There are some conflicts that may prohibit you from serving on a board, prohibit you from fully participating in the activities of the board, or limit contracting opportunities for your business. These include lobbying that requires registration, appearing before your own board, serving on multiple boards, owning an interest in urban renewal projects, and contracting with the city. Next, we'll discuss conflicts of interest that require recusal.
What is recusal?
Recusal is the act of abstaining from participation in an official action due to prejudice or a conflict of interest. To put it more simply, it means you remove yourself from participation in a decision to avoid a conflict of interest. Recusal is more than not voting. It is also not taking part in any discussions leading up to a vote, either on or off the dais. We are going to talk about how to determine when recusal is required and how to effectively recuse yourself. But first, we need to take a moment to discuss the two types of city boards. There are two types of city boards, advisory boards and sovereign boards. Advisory boards, as the name implies, have responsibilities that are purely advisory. Sovereign boards exercise independent authority. You often can't tell if your board is advisory or sovereign from the name of the board. You need to know how your board functions and whether it can exercise independent authority.
Does it really matter which kind of board I'm on?
Yes, the City of Austin and the State of Texas each have laws concerning conflicts of interest and recusal. Sovereign boards have to comply with both the city and the state laws. Advisory boards are only subject to the city ordinances. This is a very important point. Both the city code and the state law have recusal requirements. The city code applies to all city board members, but members of sovereign boards must also comply with the state law. The state law and the city code provision are similar and use similar terminology, but they are not the same. The two laws differ in some very important details, including the severity of the sanctions for failing to comply. Because it applies to all board members, I'll discuss the city's recusal requirements first. The city code requires that you recuse yourself when you have a substantial interest in a person or in an association, business, corporation, or government agency or other entity, or in a piece of real estate that would be affected by a vote of the board of which you are a member. You have a substantial interest in real property if your interest has a market value of $5,000 or more. You have a substantial interest in a person, business, or entity if you own 5% of a business or an interest worth $5,000 in a business. If during a year you receive income from a person or from a business that amounts to $5,000 in salary or professional fees. If during a year you receive $20,000 in payment for goods or non-professional services or 10% of your gross income. If you serve as a corporate officer or member of the board of directors or other governing board of an entity. Or if you owe money or are owed money by a person or a business in an amount of $5,000 or more. An interest in real estate worth $5,000 or more is a substantial interest. A substantial interest of your spouse is your substantial interest as well, even if it's separate property. If you own, partly own, or conduct business through a partnership, professional corporation, or other entity, a substantial interest of that entity is likely to be your substantial interest as well. You may also have a substantial interest in a client of a partnership, professional, corporation, or entity through which you conduct business, especially if you have recently acted in a professional or a fiduciary capacity for the client. If it appears that any of these situations apply to you, you should check further to see if you have a substantial interest. A substantial interest is affected by a vote or decision of your board if it is reasonably likely to be subject to a direct economic effect or consequence as a result of the vote or decision. The economic effect could be positive or negative. The vote or decision does not have to be the only thing that causes the economic effect or consequence, and it doesn't have to be the final action. It's enough that the effect or consequence would be reasonably expected to occur. Whether a vote or decision will affect a particular substantial interest usually requires a case-by-case consideration.
Well, let's say I do have a substantial interest. How do I recuse myself under the city code?
To recuse yourself under the city code, you must not vote, you must not take part in the discussions leading up to the vote on or off the dais, and you must publicly disclose the nature and extent of the interest. Your disclosure has to appear in the official records of the board. In other words, make sure your disclosure is recorded in the meeting minutes and on the tape recording if one is made of your board's meeting. You do not have to leave the dais to recuse yourself, but it is common practice. It's a good way to emphasize that you are abstaining from taking part in the discussion and the vote. Just be sure your disclosure is recorded in the official record before you leave the dais. Let's take a minute and watch an example of a board member recusing herself under the city code.
Okay, well, that motion fails for lack of a second. Now let's move on to item 12 on our agenda. That's consideration and possible action on a proposed bat preserve in Hyde Park.
Madam Chair,
Yes.
I'd like to recuse myself from this item. I own half interest in the property just adjacent to this site for the proposed bat preserve, so I think it's best to be removed from this discussion at this time.
Okay.
Madam Chair, would you
Yes.
also ensure that my recusal and the reasons for it are reflected in the minutes of this meeting?
Sure. Justine, will you make sure?
I sure will. It will also be on the recording.
Thank you. I think it's best to. I'd like to go ahead and remove myself from the dais and sit in the audience for this discussion.
Well, I don't think you actually have to get up and leave, do you?
I'd be more comfortable going ahead and removing myself and returning once the discussion has finished.
Okay. Let the record show that Ms. McShane is recusing herself on this item because she owns property adjacent to the proposed bat preserve. And also, let the record show that Ms. McShane will be in the audience while we deal with this item. Have you got that?
I do.
Okay. Let's move on to the item.
Let's review your requirements under the city ordinances. All city boards are subject to the city ordinances regarding conflicts of interest and recusal. You must recuse yourself if you have a substantial interest in a person, association, business, corporation, or government agency or other entity, or in a piece of real estate that is reasonably likely to be affected by the vote or decision. To recuse yourself, you must make a public disclosure revealing the nature and the extent of your substantial interest. You must make sure your disclosure is recorded in the board's official records. You must not participate in the discussion and you must not vote. You do not have to leave the dais, but it is a common practice. Now let's talk about the state law that requires recusal. The state law only applies to sovereign boards. This law applies in addition to the city's recusal requirements, not instead of them. So if you are a member of a sovereign board, you will need to be familiar with the city and the state requirements. Remember, sovereign boards have the power to exercise independent authority. It is this overall power that determines whether you are subject to the state law, not whether any individual action by the board is an exercise of independent authority. If your board is more than advisory, if it can exercise independent authority, the state law applies to you as a board member. It doesn't matter if a particular board action is merely advisory. If you are on a sovereign board, the law applies to every action you take as a board member. The state law is found in Local Government Code Chapter 171. A violation is a Class A misdemeanor, so it's important to know if your board is sovereign or advisory in nature. The state law requires you to recuse yourself if you have a substantial interest in a business entity or piece of real estate that would be affected by a vote or decision of your board. Under the state law, you have a substantial interest in a business entity if you own 10% or more of the voting stock or shares of the entity, or you own 10% or more or $15,000 or more of the fair market value of the entity, or if you received funds from the business entity that exceed 10% of your gross income for the previous year. You have a substantial interest in real property if your interest is in equitable or legal ownership in the real property with a fair market value of $2,500 or more. Under the state law, recusal is required when it is reasonably foreseeable that the board action will have a special economic effect on the business entity or real estate in which the board member has a substantial interest that is distinguishable from the effect on the public. Like the city code, the state law prohibits you from taking part in any discussion leading up to the vote.
Okay, let's say I'm on a sovereign board and I have a substantial interest in the next vote. How do I recuse myself under the state law?
To recuse yourself under the state law, you must publicly disclose the nature and extent of the interest by filing an affidavit with the city clerk. You must not vote, and you must not take part in the discussions leading up to the vote, on or off the dais. State law requires that you file your affidavit with the city clerk before the vote. If you are on a sovereign board, it is extremely important to review each meeting agenda well in advance of the meeting. If you discover you have a substantial interest in a matter that will be before your board, you must file your affidavit before the vote. Many board meetings take place away from City Hall or during the evening when the city clerk's office is closed. Don't put yourself in a situation where you need to file an affidavit, but time or location prevents you from doing so. File your affidavit before your meeting. The city clerk's office can provide you with a form to use as an affidavit. Remember, the affidavit requirement applies only to members of sovereign boards when they are required to recuse under the state law. It does not apply to members of purely advisory boards.
What if I announce my substantial interest during the meeting, but forget to file my affidavit with the city clerk?
If you don't properly recuse yourself under the state law, you could be subject to prosecution for a Class A misdemeanor. This offense is prosecuted by the county or district attorney, and it is punishable by a fine of up to $4,000, a year in jail, or both the fine and time in jail. That's why it's so important to know what type of board you're serving on and to recuse yourself properly under the state law. So let's review the state law requirements. Sovereign board members are also subject to the state law regarding conflicts of interest and recusal. You must recuse yourself if you have a substantial interest in a business entity or in a piece of real estate that is reasonably likely to be affected by the vote or decision of your board. To recuse yourself, you must file an affidavit with the city clerk before the vote, you must not participate in the discussion, and you must not vote. Once again, you do not have to leave the dais, but you might find it helpful to do so. Let's take just a moment to look at the difference between sovereign boards and advisory boards with respect to substantial interests that belong to your family members. If you are on an advisory board, you have a substantial interest if your spouse has a substantial interest. However, if you serve on a sovereign board, you are considered to have the same interests as a much wider group of relatives. Under the state law, if you are on a sovereign board, you are considered to have the same interests as someone who is related to you in the first degree by blood or by marriage. For sovereign boards, the city code extends this group of relatives to the second degree. Relatives in the second degree include your and your spouse's siblings, parents, grandparents, children, and grandchildren. It also includes the spouses of all these relatives. If any one of these relatives has a substantial interest, you are considered to have that same interest. Now you have a basic understanding of when and how to recuse yourself under the city code and the state law. It's important to realize, however, that laws and regulations cannot possibly cover every situation that could arise or contemplate every relationship or emotional tie someone might have to an issue. So, use your best judgment. If you feel you can't separate your personal feelings from a decision, you are always free to recuse yourself. If you think the public would think your relationship to a particular issue is suspect, you can recuse yourself. The law can deal with specific amounts of income and degrees of kinship, but it can't deal with every emotional tie or informal relationship you might have. For example, a domestic partner, a boyfriend or a girlfriend, or an old college roommate. The public and the press, however, have little difficulty understanding these kinds of relationships. Don't forget that appearances count, and remember the 5 principles of good government. Your actions as a board member should honor these principles at every step.
What if my board deals with federally funded programs or activities? Are there federal conflict of interest rules?
Yes, members on city boards that review federally funded projects or activities are subject to federal conflict of interest requirements. Each federal program has its own conflict of interest requirements. In addition, requirements set by federal agencies may vary from program to program and from agency to agency. The penalties for failing to comply with federal conflict of interest requirements can range from the loss of an opportunity to participate in a program to civil or criminal liability. On the other hand, complying with the federal requirements will not ordinarily excuse you from failing to comply with the city or state requirements. If your board has a role to play in federally funded activities, you should become familiar with the specific rules that apply to that federally funded program. Well, we've covered a lot of information so far. We have 2 more topics to discuss before this training is over: gifts given or offered to city officers and employees, and financial disclosure. The city ordinance on gifts is strict. It prohibits some gifts that might not even be subject to prosecution under the state's bribery and gifts to public servants law. As a city board member, you are subject to this ordinance. First, let's talk a little bit about the state criminal laws concerning bribery and gifts to public servants. Bribery is the intentional solicitation, offer, or acceptance of anything of value as consideration for an official act, including a vote or a recommendation. Bribery is an offense under the Penal Code, and it is a felony of the 2nd degree. The acceptance or offer of gifts from a person subject to your jurisdiction, with some exceptions, is also a crime. It's a Class A misdemeanor. Unlike bribery, which requires the intent to buy or sell favors, the offer or acceptance of a gift is a crime even if there is no bad intent on the part of the gift giver or the public servant.
How do I know if someone is subject to my jurisdiction?
If your board has a role to play in the purchasing decisions of the city, a person is subject to your jurisdiction if the person is or is likely to become interested in a purchasing matter that would come before your board. Or if your board plays a role in one of the city's regulatory functions, such as land use or zoning matters, a person is subject to your jurisdiction if the person is or is likely to become interested in a regulatory matter that would come before your board. Now let's look at the city's ordinance. Under the city ordinance, you may not accept or solicit any gift or favor that might reasonably tend to influence you in the discharge of your official duties. Accept or solicit any gift or favor that you should know has been offered with the intent to influence your official conduct. Or accept or solicit any gift or favor that you should know has been offered with the intent to reward your official conduct. Let's look at the first prohibition. You may not accept or solicit any gift or favor that might reasonably tend to influence you in the discharge of your official duties. Basically, it prohibits positive things or acts that might influence your behavior. It does not matter if your behavior is actually influenced. The test is whether the gift would tend to influence a reasonable person's behavior. Now let's take a look at the remaining 2 prohibitions. You may not accept or solicit any gift or favor that you should know has been offered with the intent to influence your official conduct. You may not accept or solicit any gift or favor that you should know has been offered with the intent to reward your official conduct. The important phrase in both of these restrictions is offered with the intent to. Both of these restrictions center on the intent of the donor in offering the gift or favor. It doesn't matter if you are in fact influenced, and it doesn't matter if a reasonable person would be influenced. The only thing that matters is the intent of the donor. If the donor intends to either influence you or reward you with a gift, the rule says you can't take it. Remember that influence is not the same as actually buying your vote. It does not matter that you ultimately vote against the donor's position. Also be aware of your position as a board member. If someone with interest before your board offers to pick up the check, it is a safe bet that they hope to make a good impression on you. There is no minimum amount that is allowable under the city ordinance. When 2 or more sides of an issue are represented, one party will undoubtedly walk away with the more desired or preferred outcome. Again, it's crucial that all parties view the political process as ethical and unbiased. We have all been in situations where our opinion is in direct conflict with someone else's opinion. Oftentimes, there isn't a clear-cut right or wrong response to opposing positions taken on an issue. However, these opinions or opposing positions can create competing interests. A governing board often finds itself faced with competing interests when approached by community members who are petitioning a particular issue. They then must make decisions that often have a negative or positive effect on the lives of many individuals. When a board votes, one party will be seen as the winner, and the other will feel like the loser. If board members are seen to accept gifts or hospitality from either side, either before or after a vote, the credibility and public acceptance of the board's ultimate decision will suffer. It's critical that government officials or appointees realize their actions will be scrutinized by the public, particularly by those who are involved in the political process and view themselves as the losing party or the unsuccessful petitioners of an issue. If you do accept a gift, you may be required to disclose it on your annual financial statement.
What is an annual financial statement?
The city requires most of its board members to annually disclose a number of things about the members' personal finances. These disclosures are kept on file in the city clerk's office and are open to the public. The requirement to file a personal financial statement varies from board to board. However, most city board members will be asked to disclose their sources of occupational income, ownership of real estate, ownership of securities, and their creditors. Most board members will be asked to disclose the identity of anyone other than a close relative from whom they have received one or more gifts that, when added together, total more than $100 in value. You will want to check on the exact disclosures that will be required for your board. If you're not comfortable with these required disclosures, you may want to rethink your decision to serve the city as a board member. You must file a disclosure covering the previous calendar year within 30 days of your appointment. After that, the disclosures are due by the last Friday of April each year. It is possible to file your personal financial statement online, or you can pick up a copy of the disclosure form at the city clerk's office. Well, that concludes our training. I haven't covered every situation that could arise during your service as a board member, but you should have a basic understanding of the conduct that is required of you by the city and our citizens. Don't be discouraged or intimidated, and don't be afraid to ask questions. The law department and the city integrity officer are here to assist you.
Once again, I'd like to sincerely thank you for volunteering your time and energy for this important public service. As public servants, we are held to a higher standard. If we accept that standard as a badge of honor, and if we remember and respect the purposes for which the standard exists, it's not difficult to live up to it.
Thought you'd go right on living. They cantankerous, stubborn old coops that you love. Even though our views were politically different, you're the pillar of strength I always wanted to be.